Good afternoon, RANM members. I'm Ashley STRAUSS-MARTIN, General Counsel for the Realtors Association of New Mexico, and I'm here to talk to you today about some significant changes to the RANM Form 2104, the Residential Purchase Agreement. The addition has not resulted in major changes to the way the purchase agreement works, but rather has a significant impact on the way the purchase agreement functions. In paragraph 3, we added a new section and concept entitled the Time Off Market Fee. So what is this? This is a fee that goes directly from the buyer to the seller to compensate the seller for taking his or her property off the market for a period of time to enable the buyer to conduct his or her inspections and review the seller's property disclosure statement. There are no refunds and no credits at closing for this fee, and I'll talk more about that in a moment. The idea is that there will be no after termination disputes over the TOM fee because it's not being held by a third party and has been earned by the seller up front. It's important to note that this is not a penalty for terminating. It's compensation for the time seller is taking the property off the market for the buyer to conduct inspections. The market and property will dictate the amount, which is completely negotiable. I will note that this in no way stops the seller from accepting backup offers, as you can see in paragraph 3. Most importantly, brokers need to educate their customer clients and let them make the decision on the TOM fee. But first, why did we do this? The reality is that earnest money disputes are on the rise, and a large portion of earnest money disputes occur when contracts terminate because of inspections. Either buyer terminates by objection deadline, or parties cannot resolve buyer's objections by the resolution deadline. As we all know, title companies won't release earnest money without a signed agreement to distribute, or a judgment from the court. If there's no agreement or judgment, the title company has to eventually give the money to the state as unclaimed property, and in this case, nobody wins, except our great state of New Mexico. In some rare cases, the title company won't open another escrow on the same property until the earnest money issue has been resolved and the earnest money distributed. And earnest money disputes keep buyers, sellers, and brokers tied up in transactions long after the transaction has terminated. Title companies have asked for an alternative for years, and I have approached the Forms Committee with this issue before. This is the first time that the committee has been open to a solution such as this. At the time I brought this concept to the committee, I didn't realize it wasn't novel, but I have since learned that in Texas and other states, they've had similar provisions in their contracts for a long time. In Texas, it's called an option fee, but it works the same way. I will also note that in Texas, this amount is typically between $50 and $200, but again, the amount is completely negotiable. We opted to call it a time-off market fee for two reasons. First, when the contract terminates from inspections, especially when a buyer has not even given the seller an opportunity to cure any objections, and the seller has to give back all of the earnest money, we often hear from the seller, "But I had my property off the market for 2 weeks or 10 days or whatever time frame was agreed to." We call it the time off market fee to emphasize to the seller that they have received compensation for this upfront payment that went right into their pocket and does not have to be refunded. And from a buyer's perspective, the buyers need to feel like they are getting something for this non-refundable fee. And the committee felt that the name of the fee emphasized the value the buyer was receiving for the fee. So why no credits if the deal does close? This was a hotly debated topic in the committee. Ultimately, the committee decided against a credit for this reason. To credit the TOM fee at closing ties it to the closing of the contract. As you are aware, under many laws and regulations, such as the HOA law, the condo law, FHA, VA loan program, etc., a buyer is entitled to terminate a contract without any penalty. We wanted to emphasize that this fee is not a penalty for termination. It is earned by the seller for taking the property off the market, no matter how the deal turns out. The committee felt that keeping the TOM fee separate from the earnest money, treating it differently, really highlighted the fact that it was not a penalty for termination. So what about the earnest money? Well, it's still alive and well for other contingencies, such as the appraisal or financing, surveys, other inspections that will be conducted by the buyer, title, assessments, review of other documents. So throughout the purchase agreement, when it references earnest money, it now says if delivered. It's important to recall from the time off market paragraph that the fee is only tied to one objection period, the period in paragraph 21F. Also recall that in the grid, we have tied the objection and resolution deadlines for the seller's property disclosure statements to the same deadline set forth in paragraph 21F. We did have discussions in the committee about automatically tying more deadlines to this 21F deadline, but opted against it. But that doesn't mean that you and your customer or clients can't do so. So what's the relevancy of this? Well, you'll notice in the earnest money paragraph, the new paragraph 4, The parties can opt to have earnest money delivered once the parties have reached resolution on the inspections and review of documents that fall under paragraph 21F, or by that objection deadline in paragraph 21F if the buyer has no objections. This means that the more inspections that can be conducted and documents reviewed before that objection deadline and resolved before that resolution deadline, the less likely it is the contract will terminate after the deadline due to inspections, and the less likely the parties will end up in an earnest money dispute. Because again, the earnest money will not be due until those issues revealed by those inspections and documents have been resolved. So if parties want to include additional inspections, document review, or contingencies in that time frame so that the parties get as many resolved before earnest money is due, they'll want to use those same deadlines as set forth in paragraph 21F for other inspections, document review, and contingencies. On the other hand, if one or both parties want to delay certain inspections until after the party know the deal is going to survive, certain inspections or review of certain documents, they'll want to push those deadlines back. For example, if a seller doesn't want to pay for a septic inspection until the buyer's home inspection issues get resolved, then in the septic addendum, the seller may push back the date by which he or she must order the septic inspection until a date after the buyer's objections to the home inspection have been resolved. If they don't get resolved and the contract terminates, then the seller hasn't spent money on the septic inspection, which is only good for 180 days, as we all know. That's not really any different than how it works now. We don't have addenda for all inspections in the paragraph 21F. So other inspections or documents the parties want to pull out of paragraph 21F may need to be placed on an amendment. For example, if the parties wanted to delay a well inspection until after the home inspection issues have been resolved, they would have to do so on an amendment because the well inspection is currently under the paragraph 21F deadlines. With all this said, most importantly, brokers need to educate their customer and clients and set the parties' expectations. Ultimately, the decision to use the TOM fee, which is not required, needs to come from the parties, not the brokers. One of the first things you should explain to your customer or client is that just because the purchase agreement is clear in most cases about who should get the earnest money, the release of the earnest money will not happen automatically. There is no magical earnest money fairy who will wave a wand and put the earnest money in the pocket of the party who clearly is supposed to receive it under the contract. Instead, the parties will have to agree to distribute it or it won't get distributed. Next, it's important to inform your customer and clients of the process if parties cannot agree to the distribution of the earnest money. Talk to them about the ombudsman program, the mediation program, which we know is not free, and litigation. Nobody wants to litigate. And finally, explain that the time-off market fee avoids much of this. It's also important to emphasize to your sellers that if the buyer walks after inspections or document review, the TOM fee is all, and the emphasis is on all the seller gets. And to emphasize to the buyer that the TOM fee is not going to be refunded or credited unless otherwise provided for in an amendment to the contract, so that the buyer understands this money is gone, again, for good cause, so the seller would not actively market the property, but nonetheless gone. And again, this does not prohibit the seller from accepting backup offers, as they have always done. Like earnest money, setting buyers and sellers' expectations on the TOM fee will avoid conflicts when the deal terminates. In my experience on the hotline, so many buyer and seller disputes could be avoided if the parties had understood the contract and knew what to expect before the issue arose. In closing, I will say that change is hard, but it can be really good. We are not going to know if this new TOM fee will reduce the number of earnest money disputes unless we try it. So get comfortable with the concept and how to use it in the best way possible to represent your customers and clients. These changes will be available in Instanet and Zip Forms on October 1st and in .loop on October 1st or shortly thereafter. If you have any questions about these changes, please contact me on the RANM Legal Hotline. Thank you and have a great day.